Hi, we now move to the second part of the first lecture. We're going to be covering the following things towards your right. We'll start with the types of state system, move to the electoral matrix, cover types of majorities, apply those majorities to lawmaking, understand the four golden rules of polity, and glance through what specifically should you be reading from your standard sources. So let's move to the types of state systems. Now, when we look at the types of state systems, we understand that there are broadly two kinds of state systems. One, we understand them through a political standpoint, or we also understand them through an economic standpoint. Let's focus first from understanding them from a political standpoint. So, largely, you either have a democracy or you don't have a democracy. Now, there could be further variations of the same. It could be an anarchy, it could be a dictatorship. But the basic difference between a democracy and any other form that could exist in the world is the lack of reflection of public will. If there is a reflection of public will, a participation of public will, then conceptually, theoretically, you are a democracy. Whether you are a functioning democracy, a vibrant democracy, or a sleeping democracy, that's of course an argumentative debate for another time. But because we are in a democratic country and the prelims is not going to ask you which of the following is not meant by a dictatorship, or a dictatorship comprises of which of the following, you don't have to particularly worry about this. What you have to worry about is the forms of democracy. Now, democracy largely takes two forms. Both of these forms can coexist in different capacities at the same time, or one of the other two forms can exist. So, democracies are either direct or indirect in nature. A direct democracy is where populations or people actively participate in decision making. This of course is a volume issue. This of course has certain logistical constraints, which is why you will not see this in rampant form across the world, and of course in India. In India we do have certain forms of this in a very limited manner, but we don't have a fully fledged direct democracy, so to speak. But a direct democracy is basically where people are your decision makers, whereas an indirect democracy is where people choose certain people who then become representatives and they become decision makers. So that's the basic difference between a direct democracy and an indirect democracy. A direct democracy and an indirect democracy, and a direct election and an indirect election, are two very different things. See, a direct election is when the people participate in electing a representative. An indirect election is when people choose a representative and then that representative further chooses another representative. So that's an indirect election versus a direct election. Direct democracy and indirect democracy, a direct election and an indirect election are two completely different things. For example, our Lok Sabha elections are indirect democracies because we are choosing representatives, but they're direct elections. Whereas our Rajya Sabha elections are also indirect elections, but they're also indirect democracies because they're representatives, but they're also indirect elections because Rajya Sabha elections, the people who are already serving MLAs choose Rajya Sabha MPs. So a representative is further choosing another representative. So let's come back and let's discuss direct elections or direct democracies. Sorry. So there are largely four forms of direct democracies. A simple way to remember this is a mnemonic called RIP, which stands for rest in peace, and a version of this could be R square IP. So you have referendum, recall, initiative, and plebiscite. Referendum and plebiscite are related to each other, and recall and initiative could be understood together. Let's start with the easy ones first. The underlying principle, as I said, as far as direct democracy is concerned, is people directly taking decisions. So, what is a recall and what is an initiative? And please bear in mind, these are theoretical ideas. You may not see them in practice in their totality in and around you. So, recall simply means when the people of a country, of a region, decide that a public office must be vacated. This public office could belong to anybody, could be a judge, could be a minister, could be a bureaucrat, it doesn't matter. You want that public official to no longer hold that post. That's called a recall. For example, let us say if there are massive protests at Jantar Mantar demanding the resignation of a certain person, that could be a recall mechanism by a far stretch of imagination. This is not legally recognized anywhere in India. There is no law that says recall is valid or recall is recognized as an institutional practice. Initiative is the opposite of recall in terms of recall being negative and initiative being positive. So what happens in an initiative is that the people of a region or a country or a state or a population propose that the government should do something. The formulation of a policy, the formulation of an idea comes from the people. That's called initiative. For example, you could say the net neutrality movement in India was an example of initiative. You could say, for example, the Anna Hazare sort of leadership movement called the India Against Corruption movement, which led to the formulation of the Jan Lokpal, which is basically another anti-corruption legislation, was an example of initiative. Again, not legally institutionally recognized in India. Nowhere does it say that if the people bring an idea to the government is duty bound to accept it, duty bound to process it. Morally, yes, legally, perhaps no. But that's what a recall and an initiative is. Now comes referendum and plebiscite. Now, to understand the difference between referendum and plebiscite, we've got simple questions to answer. The questions are, first, who is conducting it? Second, what is being asked of the people? And third, what happens after the people have been asked a certain question? So referendum and plebiscite is where people are asked of their opinion on something. Now let's understand the first question. Who conducts a referendum and who conducts a plebiscite? See, a referendum is usually conducted by the government, and a plebiscite is usually conducted by a third party, in most common cases, the UN. That answers the first question. The second question, what do you ask the people? So in a referendum, the government asks its citizens, its people, their opinion or their vote on literally anything under the sun. They could ask the people, do you think we could leave the European Union, Brexit, for example? They could ask whether a law should be passed. They could ask whether marriageable age should be reduced. They could ask the opinion formally on anything, literally anything, and that's a referendum. Whereas in a plebiscite, you would usually ask people a singular question, and that question is on self-determination. What is self-determination? Self-determination is you ask the people, do you want to be a part of the country that you're currently a part of? Yes or no, right? Like for example, we were to almost conduct a plebiscite in J&K post-independence, conditioned on the fact that the Pakistani army withdrew its troops from what is today called the Pakistan occupied Kashmir, and India had agreed to this, but since Pakistan did not withdraw their forces, we didn't conduct a plebiscite for that matter, right? And that's the second question, which means if the government asks you a self-determination question, it's a government conducted plebiscite, which is also a referendum. So a plebiscite can be a referendum, but a referendum can never be a plebiscite. That's basically the correlation. And the third question is, what happens after people's opinions are sought? In India, in both the cases, you don't technically have a legal value to this. Even if the government conducts a referendum, there is no law that says you're duty bound by it. Though you should be, but you're not duty bound by it. In the UK, referendums are formally binding. Plebiscites are anyways never binding on the government because the government is not conducting the survey or is not conducting the opinion. So these are basically forms of direct democracy. And what is common to referendum, recall, initiative and plebiscite is that either people are telling the government something or the government is directly asking the people something. But the decisions are in and around the people, and that's what makes a democracy a direct democracy. In India, the closest that we come to an institution of direct democracy is actually the institution of Gram Sabha, which is a part of the local self-government in the rural areas, where anybody who's in a village above the age of 18 is automatically a member of the village parliament, which is called the Gram Sabha. You then choose your prime minister of the village, which is called the sarpanch, and the council of ministers in case there's a gram panchayat. But that's the closest where we come, where every adult member of the village is a part of the village legislature called the Gram Sabha. That's one of the closest examples that we have to direct democracy in India. Now, let's look at indirect democracies. You see, there are essentially three kinds of indirect democracies, and they function on the principle of whether you want power to be concentrated or do you want the power to be distributed. If the power is concentrated, it is less accountable, but if the power is distributed, it's more accountable. If the power is concentrated, then actions are faster, decisions are faster. But if the power is distributed, it's more accountable, but decision making is often longer. It's a basic logical correlation. On the basis of that fundamental principle, you've got a presidential form of government, a parliamentary form of government, and a semi-presidential form of government. And here we use two terms. One is called HOS, head of state, and the second is called HOG, head of government. Now, let me explain this to you. Let me explain to you the broad rationale behind a head of state and a head of government. I'll give you a simple, unrelated legal example. For example, you go and buy a Cadbury chocolate, and the chocolate is sealed, is kept in a refrigerator at a shop. You buy it. You open the chocolate and you find a worm in it. You will, under ordinary circumstances, file a consumer case against the company Cadbury. You will not file it against the shopkeeper. You will not file it against the owner of Cadbury India. You would file it against the company. The point being, the company Cadbury and the owner of Cadbury, under the eyes of the law, are two different legal persons, right? This gives birth to the idea called a differentiated legal responsibility. Similarly, when we look at formation of government, we see two differentiated legal identities. One, the head of state, under whose name are actions taken, and two, head of government, wherein the power to take those decisions lie. Now, in some cases, they'll be the same person. In some cases, they'll be different people, and that is how you have differentiated forms of indirect democracies. So basically, in a presidential system, the head of the state and the head of the government is one person, which is the president. So absolute power is concentrated in one office. The ceremonial or the nominal power and the real power also. Ceremonial and nominal power is usually associated with the president. Real power is associated with the prime minister, as you would see in a parliamentary system of government, wherein the head of the state could either be the president, in case, it's an elected head of state, because the head of the state is ceremonial or nominal. It doesn't matter as much as to how you become a head of state, which is why in some cases you have hereditary head of states. So those are called monarchs. But if you have an elected head of state, you will always be a republic, which is why all presidential democracies are always republics, but some parliamentary democracies are not republics, right? Some cases, for example, UK is not a parliamentary republic. It is a parliamentary monarchy, because the head of the state of the UK is hereditary, which puts it one step behind an elected head of state, which is why, at least in India, you would hear of the president exercising their veto or exercising some adverse function once every decade. But the last time the Queen of England said no to something was about 150 years ago, which is also almost the age of the current Queen of England. Anyways, but this is what is called a head of state. So in a parliamentary system, the head of the state and the head of the government are two different people, where the head of the government is the prime minister, who also heads the council of ministers. But they're two different people. Real power lies here, and nominal or ceremonial power lies here. There's a clear distinction of power distribution. Whereas in a semi-presidential system, you have some powers to head of state, and you also have some powers to the head of government. Naturally, if you have a concentrated power ability, you will try to give the head of the state more powers than the head of the government, which is usually seen in semi-presidential cases. But the difference largely here is that in a presidential form of government, the head of the state is not accountable to the legislature. They're two very distinctive bodies, which is why you will see separation of powers in its most magnificent form in presidential democracies, whereas slightly in a diluted form in parliamentary democracies, because here the head of the government is accountable to the legislature, and in the presidential system, that's not the case. And in a presidential system, the president is usually directly elected. Now, the process of election could be complex and could have several ramifications to it, but no doubt there is some form of direct election in a presidential form of government, right? Now, that's the basic difference between the three. Now, classic examples, US is a presidential form of government, India is a parliamentary form of government, and Sri Lanka is a semi-presidential form of government. Even Russia, for that matter, is a semi-presidential form of government. But what you need to clearly understand here is distinction between head of state and head of government. And on the basis of that distinction, several ramifications follow. Like, for example, presidential governments may be able to make faster decisions. They will be lesser accountable to the legislatures, right? There will be more power concentrated in the top office, as opposed to a parliamentary system where there is greater accountability. There is some form of accountability of the head of the government to the legislature, and so on and so forth. So, from a political standpoint, these are your three primary forms of government. When we get to president and parliament in our subsequent lectures, we will talk about this in a fair amount of detail, but this is enough to set the base up and running for you. From an economic standpoint, we largely look at two forms of economic systems, a capitalistic economic system and a socialist economic system. And the difference is largely from a very foundational point of view in terms of resource ownership and allocation. Usually in capitalism, resources are private resources, and anybody and everybody has absolute access to utilize them and is under no obligation to give back to society. And the governments play a very, very limited role in these free market economies, which are also called capitalistic societies. The exact opposite of this is socialism, where the role of the government is higher, where all resources are actually national resources. They're owned by the government. There is an obligation on the government to own, operate, and distribute resources. And therefore, if it is the obligation of the government, then the government is obligated to distribute the benefits of these resources equitably across its constituent populations. Now, both of these forms have their inherent merits and demerits. Capitalistic societies will tend to have a higher growth rate, better innovation, better competition, but at the same time will also breed excessive income inequality. There will be no social security and benefit. On the other hand, socialistic societies will see equitable benefit, will see social welfare, will see protection of marginalized communities, but also at the same time will see a lack of industrialization, will often see complacency in growth and deficiencies in innovation because of lack of incentivization. Now, the UPSC, I assure you, is not going to ask you questions on communism, and don't confuse communism with communalism. They are two very, very different things. Communism is considered an aggressive, distant cousin of socialism, where Theoretically, as an idea, resources are owned by the community. When we translate it into a political ecosystem, it's usually a one-party rule. But again, that's something at this junction, as far as your prelims is concerned, you don't have to be worried about, where communism ensures that there's a higher degree of social benefit, but also a very, very high degree of state intervention, which could often lead to abuse of power, as seen across nations in the world through history. But anyways, this is, in terms of types of state systems, more than enough for you to understand. You don't need anything else, and this sort of sets the tone just about right. Now, once we understand this, we now must understand from a political standpoint, when we're talking about political state systems and we're talking about democracies, democracies is always about representation. It's always about the law of averages. It's always about representation. And the word that comes to our mind is elections or electoral practices, which is why right at the very beginning in your first or lectures for Magna Carta, you must understand what is called the Electoral Matrix, where we will talk about forms of elections, we'll talk about certain key terms, we'll talk about certain key concepts. You may be asked questions from here in the prelims exam, because as we are seeing in the last few years, conceptual questions are being asked in greater detail than factual questions. So let's start with the electoral matrix. So there are essentially two kinds of elections: direct elections and indirect elections, as we were talking about earlier. In a direct election, the citizen chooses the representative, and that's done. The representative then performs a certain amount of action. In India, you will see this across your lower houses, such as the legislative assemblies, Lok Sabha, Gram Sabha to an extent. These are essentially direct elections, right? Whereas indirect elections, on the other hand, is the citizen chooses representative A, who then participates in a further election to representative B. Right? You'll see this in vice presidential elections, Rajya Sabha elections, legislative council elections, and so on and so forth, in some local self-government elections as well. And this is also where you often see two terms. One is called an electorate, and the second is called electoral college. They are sort of versions and variations of each other. The basic explanation here is an electorate is basically the bunch of voters in a direct election. So you and I, as people above the age of 18, constitute the electorate of the country, and above the age of 18, everybody has the right to vote, with of course certain terms and conditions, makes the institution of universal adult suffrage come to power. Until 1989, the age to vote was 21. They reduced it to 18 post 1989, among a host of other electoral reforms. Now, an electoral college is basically choosing the representatives who will then participate in the election to representative B or of representative B. And because democracy is about the law of averages and it is all about representation of public will, putting a number to that makes a lot of sense, without which democracy would seem a farce. And how do you put a number to democracy? How do you say that X is a viable representation of a certain set of people? Which is why you need a tabulation exercise, which is called census, right? Which is why you need a tabulation exercise called census. Now, let's understand this far more clearly. So what is a census? A census is nothing but, we'll do this in a fair amount of detail in our citizenship class when we do NPR census and NRC, but a census is nothing but the calculation of the number of people across certain parameters living in India. A census is not a calculation of Indian citizens, it's about people living in India. I'm not using the term ordinarily resident because that's an NPR term. We're talking about a calculation of people living in India and checking through various parameters. So you have demographic, biometric, social parameters, and so on and so forth. But why do you need the census? It's again a decadal exercise, by the way, and contrary to popular belief, census is actually managed under the broad supervision of the Home Ministry. You need it for three reasons. First, when you have to allocate the number of seats to an electoral house. 2, you have to identify or demarcate the size of the constituency. And third, of course, figuring out how many times a vote will be counted, if it has to be counted more than once. You'll understand this in the next 2 minutes or so when we talk about proportional representation and so on and so forth. But broadly, this is why you need the census. You need the census for 3 things. First, calculating the number of seats, right? If we have 543 seats in the Lok Sabha, why do we have that 543 number? 2, if we say that a heavily populated area will have a lesser constituency radius, it's because in a state we would want approximately the same number of people in a constituency. It's very important to keep in mind that constituencies in India are arranged state-wise, whether it is an MP constituency or, of course, by definition, an MLA constituency. The general principle is that barring a 15% margin given by ECI, then the size of constituencies in a state should be such that approximately the same number of people reside in each of those constituencies. And when you change that, it's called delimitation, which is done through the Delimitation Commission, whose orders can't be challenged in a court of law under ordinary circumstances. We'll come to that later. But that's what is called by a size of constituency, and of course vote values. Now, what we've done is we've taken 1971 as the base year, largely because it represents a median in terms of our population growth trajectory over the last few years, and we've frozen this number till about 2026 to make sure that A, we've got an accurate assessment here, and 2, to ensure that governments in power don't abuse this to restructure electoral differentiations. Size of the constituency can be updated through the most recent census, whether it's 2001 or 2010 or 2011, which is the last proper census that happened, because 2021 census could not happen due to the pandemic. This was also in news with respect to the delimitation exercise in J&K. And third, of course, the vote values are also determined on the 1971 census. So in 2026, when we're going to revise the number of seats, it's expected that at least the number of Lok Sabha seats would multiply by 2. And one of the reasons given by the government is that we need a bigger parliament, and therefore the Central Vista project makes sense, because we'd largely have more number of MPs, and our current parliament will not be able to host about 1,000 MPs in the Lok Sabha itself. So this is the base for an electoral matrix. Now we get into the technical details in and around it, right? So when we look at an electoral glossary, we understand that you've got the Election Commission of India under 324, which is a constitutional body, and we'll come to that eventually. And you've got the Representation of People Act. There are 2 acts which largely govern elections in the country. And the electoral process essentially has 4 sort of stages. First is you've got a bunch of people who vote. These are called voters. And what they do is that they cast a vote. Then the votes that they've casted has to be counted. And once the votes have been counted in a certain manner, there is an outcome to that entire process, right? Now, on these 4 parameters, will you see certain terms that come out of it? As we've discussed before, you will have you and I as your average voter in a direct election, called the universal adult suffrage. You will have representatives who will be your voters in an indirect election, how your MLAs is your electoral college for Rajya Sabha elections for that particular seat in a state, or your Lok Sabha, Rajya Sabha and your state elected MLAs are your electoral college for the election to the president. So that is an indirect election, that is your electoral college. Now you decide to cast your vote, and this is not an absolute universal right. There are certain terms and conditions to this. For example, in India, prisoners don't have the right to vote because you're not of a sound mind as you are a prisoner, and therefore you don't have the right to vote. We also have concepts such as the postal vote, because a lot of times People in the service, people in the foreign services, people in the armed forces and their spouses are not able to vote because they are away from the constituency where their names are in that specific voting list. So you can always cast your vote through a telegraphic means. And then comes the process wherein your votes have to be counted. Now, usually in direct elections, one vote is counted once. Simple, no confusion, no problem. But in some very, very rare cases, one vote may be counted more than once, right? This is called a value vote system. This is fairly similar to, for example, the IMF, right? The number of times your vote will be counted at the IMF depends on how much money have you funded the IMF for, which is why we often say that the US has an upper hand at the International Monetary Fund, because the US historically has been one of the highest donors to the IMF, right? So it's not necessary that one vote will be counted only once. In some cases, in some electoral processes, usually in indirect elections, will you see one vote counted more than once, right? Now, that's how the votes are counted. After the votes are counted, then we've got to figure out the results to that vote. Now, there are two very simple ways to go about it. Either a person has gotten more votes than everybody else, a simple process that India uses, especially in our parliamentary elections, in our lower house elections. This is called first past the post system, where you get more votes than everybody else. We'll do a deeper analysis of this in the next slide. And the second is, you've gotten a majority of the votes. You've gotten most votes. If there were 10 votes, you've gotten 6. That is called proportional representation. First past the post would be, let us say there are 4 contestants, A, B, C, D. There have been, let us say A has gotten 4 votes, B has gotten 3 votes, C has gotten 2 votes, and D has gotten 1 vote. This makes a total of 10. Through first past the post system, A has been declared the winner because A has more votes than everybody else. This still means 60% of the people don't want A, but that's the story for another time. But this is what is called first past the post system. Most people may not want you, but you still have more votes than everybody else who was fighting for the same spot. Proportional representation in this case would mean A would need 6 votes to win. And because A would need 6 votes to win, A will not be declared the winner until A has 6 votes, or whoever gets 6 votes, which means you will have to redistribute the votes. And the only way you'll have to redistribute the votes if the votes are casted on a preference basis. That every vote will have my first preference A, B, C, and D. So the person who's gotten D, the person who's given D as the vote, obviously D is their first preference. You'll check for their second preference. If the second preference for this person is A, then you will give D's vote to A and you'll eliminate D anyways because D has no chance of winning. So you'll keep doing that. This is called single transferable vote. We'll talk about this. But largely, the basic difference is if you get more votes than everybody else, this is called first past the post system. And if you need to get a majority of total votes, basically a 50% plus 1, that's called proportional representation, right? Now, when we look at a comparison between first past the post and proportional representations, what do we understand? The basic difference is that first past the post system is very candidate centric. Now, don't think of proportional representation as a Rajya Sabha or a presidential election. Look at it from its purest form, right? So when we talk about first past the post system, it is candidate centric. If there is a constituency C5, right? There are 5 candidates contesting to become MPs from C5. Whoever gets more votes than each other, right, automatically wins. The focus is on the candidate. That candidate may be backed by a party, may not be backed by a party. But the voters have been given that choice to strike that balance. There is individuality and there is accountability at the same time. However, in proportional representation, theoretically, it is party-centric. The candidates are just mere formalities. The candidates have to theoretically be aligned to the parties. That's the basic difference. Now, in a first past the post system, whoever gets more votes than the others, as we were talking about, wins. In a proportional representation, it's usually getting more than 50% votes, getting most of the total votes polled. And of course, this has certain ramifications. As I was telling you, in that case, where A got 4 votes out of 10, but A got more votes than B, C and D, A is still the winner, which means A is going to represent constituency 5. And let us say A comes from party X. Similarly, let us say here E comes from party X. Let us say F comes from party X. And all of them just have a 40% vote share, which means 60% of the people in each of their constituencies still don't want them. But comparatively, they are still getting to be elected. This means vote share may be low, but parties will still be able to form government. This is a very common phenomena in Indian politics, right? And usually you divide the country into constituencies. In India, we arrange it state-wise, and India and UK are fantastic examples of the same. However, in proportional representation, the basic principle here is that the parties are allotted seats in proportion to the votes that they get, which basically means, let us say there are a total of 100 seats, and let us say there are 5 political parties, right? The number of seats that they are going to get will be in proportion to the number of votes that the party has received. That's the basic example. That's the basic understanding. So if A has received, if political party A has received 25% of the votes, for simplistic purposes, let us say A gets 25 seats. That's not necessarily the case here. Here, political party X is not getting 40% of the seats, right? Here, you might just, right? Now, of course, this gets implemented in multiple forms, One variation, which is often used in Israel and Netherlands for that matter, is where your entire country is one constituency. Like, for example, in the case of Israel, the legislature, I think, is called Knesset, right? Now, Knesset. Now, how does this work? All contesting parties are given seats in accordance to the percentage of votes that are polled, basically. And the entire country is one constituency, as opposed to, let us say, a version 2, which is sort of followed in Argentina and Portugal as well, wherein the entire country of Argentina or Portugal gets divided into multiple constituencies, and multiple parties can field multiple candidates in Argentina and Portugal. And depending on the number of votes that each party gets, you get different number of seats. So usually in proportional representation, you will inevitably see coalition governments, especially in these two variations. Here you may not necessarily see coalition governments if a single party gets a majority share in the legislatures. But here it is an almost certainty that coalition governments are a very likely outcome of countries which follow proportional representation of voting, right? Now, none of this actually happens in India. India uses its own version, which is called proportional representation through a single transferable vote. Now, what does this mean? This basically means two things. First, in some cases, you will require more than 50% plus 1 votes to win, such as the president. In some cases, you will require a bare minimum number of votes to win, such as the Rajya Sabha elections. To get to that 50% plus 1, or to get to that bare minimum number of votes, you can recirculate and redistribute your votes. So here in a first party system, there are no preferences. You are voting for one person. You've got one choice. Here you are saying, my first preference is A. If A doesn't work out, give my vote to B. If B doesn't work out, give my vote to A or C or so on and so forth. And you keep redistributing it. You remove the lowest contestant out of the race, redistribute the second preferences of the lowest contestant, give it to whoever the second preference is, and you keep redistributing it until you get to that magic number, which in the presidential election could be more than 50% of the total number of votes, and in a Rajya Sabha election, depending on the state and the vacancy, right? There are defined formulas for the same. So India actually uses the single transferable vote system, which is nothing but a version of proportional representation. So India uses proportional representation, single transferable vote with a certain degree of innovation. So we have a unique system, again only mostly used in indirect elections, so to speak, right? And that is something that we must very, very clearly understand. Of course, India chose this as your dominant format because it's easier, it gives the voters more choice, it allows for greater debate and is also more accountable. Here, when your entire country is a constituency, when you have multiple party members representing a single constituency, and multiple members from multiple parties representing it, it sounds more confusing than it is said. Who do you hold accountable when something goes wrong in your country, in a smaller constituency, and so on and so forth? Which is why India chose a sensible first past the post system, and the 4 reasons that we spoke about in our last lecture also, imperial past, federal balance, diversity, and socio-economic parameters still hold to be awfully true here. Right? Now we move to types of majorities. This is very simple. Now before we start, let me first make something very clear. Whether it's an absolute, effective, simple or special, the constitution does not use these words at all. Which is why in your prelims exams, if you get a question on a specific majority, they will explain the majority to you in its detailed form. They will write that a majority of not less than so and so, so and so, so and so. That's because the constitution does not use these oversimplified formats. And 2, unless it's a joint session and you would mostly be using, you will only be using simple majorities in joint sessions, these majorities are for that specific house. So majority for house 1 and this majority for house 2. Houses don't sit together. It's not a collective majority. It is a house specific majority, right? Now, how do we do this is, we divide our majorities into 2 parts. The left is the half fraction majorities, which is more than half, and the right fraction is more than 2/3 majorities. Now what is common to all of these 2/3 majorities is, in some form or the other, they are dealing with something which has a federal implication, which most necessarily is not the case here. So for example, let's start with absolute majority. You see, absolute majority is only used once, which is when you have to form government. So after the first past the post system has finished, after you have winning candidates from constituencies across states for MPs all across the country, whichever party has the most number of whichever party has the largest number of wins in such a way that it is more than half of the total strength of the house, that party gets to form government, which basically means, let's say it's the Lok Sabha, it got 543, so you will require, let us say 273 is your magic number, so you require 273. Now when we say the 273, it means 273 MPs must come from either a single party or a combination of parties willing to work together, called a coalition. And as long as you're able to get those MPs together, then is how you're able to form government. So absolute majority is nothing but whichever party is able to get more than half of the total strength of either the Lok Sabha or the Legislative Assembly or the Union Territory with legislature gets to form government. This is after first past the post system has happened and candidates have been elected, right? So this is a political majority, it's only used once. Then you've got effective majority. You see, effective majority is used only and only to remove presiding officers, and except for one presiding officer, which is the vice president, who also happens to be the chairperson of the Rajya Sabha, wherein you do use effective majority, but you also use simple majority after effective majority. So that is why it is a little complicated on that front. But every presiding officer of every central and state house, except the chairperson of the Rajya Sabha, gets removed through an effective majority. An effective majority is more than half of the effective strength. The effective strength is nothing but the total strength minus the total number of dead, disqualified or resigned MPs. Now why do we do this? We do this because if you want to remove your presiding officers, who are basically class monitors, you have to be in the class for you to have a judgment on the class monitor. If you are dead, then you are not a part of the class. You have no say in deciding whether the class monitor should be the class monitor or not, right? If you have shifted schools, if you have taken a withdrawal from the school or a withdrawal from the class, you have no right in judging whether the class monitor was a good monitor or not. And if you do so, if we count the total strength, it would be more difficult to remove class monitors because this would be a larger number. So that is why you use effective strength to remove presiding officers for all houses except the chairperson of the Rajya Sabha, right? Then you also have simple majorities. Now simple majorities is your default majority for a lot of things, right? Again, used across all houses. It is used for two reasons primarily. First, if you are making a law which is not an amendment to the constitution under 368, close your eyes, blanket simple majority. Second, all parliamentary motions of any kind will always require simple majority. Whether it's a no confidence motion, a censure motion, an adjournment motion, even a motion of thanks for that matter, all of it will require a simple majority. It's one of the two default majorities that we often use, right? It's your default non-Article 368 majority also. And this is your half fraction. Now you look at the 2/3 fraction. So the first is called special majority 1, which is more than 2/3 of present and voting. You would mostly see this to be used in the Rajya Sabha or the state legislative assemblies. I'd like to colloquially call it permissions majority. For example, when the Rajya Sabha has to authorize the parliament to make a law on something in the state list, or to make changes to all India services, or the legislative assembly has to pass a resolution wanting a legislative council, then you need to do so through a special majority 1. These are called permission majorities. And say when you are adding an all India service or authorizing the center to make a law on something in the state list, you are affecting federalism. So the whole 2/3 federalism principle still stands to remain valid, right? And then of course you have special majority 2. Now special majority 2 is basically, are you sure and are you really sure? There are two questions. You're being asked the same question twice. Do you want to do this? Are you sure? That's basically special majority 2. So it has two things. First, half of the total strength of the house must say yes, and after that, more than 2/3 of the of present and voting. So, more than 2/3 of present and voting, and half of the total strength, both the numbers should remain yes. So in a simplified form, we say more than 2/3 of present and voting in such a way that it is more than half of the total strength. But in reality, the House votes twice because you want to be very, very sure of this. You use this for two reasons. First, you use it to make constitutional laws under Article 368 without state ratification, and second, to remove constitutional bodies, Supreme Court, High Court judges. This is a very commonly used majority, right? Again, whether it's about removing a Supreme Court or a High Court judge, which will have a federal implication because Supreme Court gets to look at center state disputes. High courts are highest judicial organs of the state. There is a federal implication here, right? So this is special majority 2. More than 2/3 of present and voting, then more than 2/3 of the total strength. Are you sure? Are you doubly sure? But to simplify it, we say more than 2/3 of present and voting in such a way it is more than half of the total strength of the House. But this is largely what it is. Now, then you have special majority 3. Special majority 3 is basically special majority 2 plus X. Here we involve the lower houses, the state houses as well. So let's see how does this work. Special majority 3 will have 3 stages, 3.1, 3.2 and 3.3. 3.1 and 3.2 is exactly the same as 2.1 and 2.2, which means here also only the Lok Sabha and Rajya Sabha, here also only the Lok Sabha and the Rajya Sabha vote, wherein more than 2/3 of present and voting, then more than half of the total strength, basically that. Once the Lok Sabha and the Rajya Sabha have independently voted, there is no joint session for any of these things. After that has been done, in special majority 3, then the law is the proposal law, the bill, the constitutional amendment bill is sent to all the regional legislatures, which include state legislatures and union territories with legislatures. So Delhi, Pondicherry and J&K when it has a legislature. And out of all the legislatures, at least half of them have to pass it with a simple majority. So we've got 28 states and we've got 3 union territories with legislatures, that's 31, which means we require at least 16 legislatures to pass the same bill with a simple majority, right? So this is called special majority 3. It's nothing but special majority 2 plus X. People often get confused here. Yes, the House votes twice when you look at 2.1 and 2.2 or 3.1 and 3.2. Are you sure? Are you doubly sure? And they have to vote twice in the same session. For example, when you read the constitutional provision on the removal of a Supreme Court judge, it mentions that the House has to vote twice in the same session. Then the toughest majority of it all is special majority 4, which is 2/3 of the total strength of the House. Right? Now 2/3 of the total strength of the House is only used in one instance as far as it is concerned, and this is called a presidential impeachment, and this is called a presidential impeachment. So we start tough, we go easy, and then we go tough. This is your majority spectrum. As long as you understand this, you don't need anything else. Keep in mind, whether it is special majority 2, special majority 3 or special majority 4, all of special majority 2 only used in Lok Sabha and Rajya Sabha, all of special majority 4 only used in Lok Sabha and Rajya Sabha because center stronger than the states, and half of special majority 3, the first stage of special majority 3, only Lok Sabha and Rajya Sabha. This will help you keep most of your concepts in track in the classes to come, and also attempting questions eventually. So this is what your types of majorities are. Then you have applications of majorities to lawmaking. Now let's understand applications of majorities to lawmaking, and let us see what is it that we understand here. See, now that we understand the kind of majorities that we use, let's understand what do we use these majorities for. The most common purpose that we use these majorities for is lawmaking. That is why you have legislatures. You of course use these majorities for parliamentary tools also, to remove and elect people also. I understand all of that. But the primary function to use majorities is to essentially make laws, right? That's the primary function. And if the primary function is to make laws, we've got to do our primary function incredibly properly, right? Incredibly properly. So let's understand this. There are basically 2 kinds of laws that are ever made on the face of this country. Laws which change the constitution and laws which have nothing to do with the constitution. They are just different laws. Now, all laws that change the constitution are not called constitutional laws. There is some branding at that level. only laws which change the constitution or change those parts of the constitution which are under 368, they are called constitutional laws. They're called constitutional amendments. Constitutional amendments are only those laws which are changing those parts of the constitution which are under Article 368. Everything else, you don't call them constitutional amendments, you call them amendments, or you call them laws, or you call them anything else. Constitutional amendments are only those laws which change those parts of the constitution under Article 368. Now, there are two kinds of amendments that happen under 368, the super serious kind and the not so serious kind. The super serious kind is the kind which affects state interests adversely or affects states' interests very, very seriously. For example, when you are changing the way the president gets elected, because the president has powers to promulgate state emergency. When you are changing the legislative or the executive powers of the state, when you are changing appointment and removal powers, mechanisms of Supreme Court and High Court judges. For example, we tried to do that erstwhile through the 99th Amendment called the National Judicial Appointments Commission. Or, for example, when you're changing Article 368 itself. Or, for example, you're changing the manner of election of the Rajya Sabha, because that would mean you're changing the composition of a federal balance. All of this will require special majority for which all of this will require special majority 3, which is nothing but stage 1, Lok Sabha and Rajya Sabha, and then you have stage 2, which is when you take the same law to half the state legislatures. So special majority 3 will have 2 stages. Stage 1 would be simple, where more than 2/3 of present and voting and more than half of the total strength. Lok Sabha and the Rajya Sabha separately vote. Then the same proposal is sent to half the state to all the legislatures regionally, and half the legislatures have to pass the same proposal through a simple majority. Right? This is called special majority 3. Now, if that's not the case, if it's not affecting states, if it's not affecting states seriously, then you will require special majority 2, which is more than 2/3 of present and voting and more than half of the total strength of the House of the Lok Sabha and the Rajya Sabha. If it is under 368 and it is not mentioned, you will always assume this as your majority. So your 103rd constitutional amendment for EWS, your RTE 21A, all of these were passed through special majority 2. But 99 constitutional amendment, which tried to bring in NJAC, will required special majority 3, right? If it is not mentioned and it is a change to the constitution, then you will assume special majority 2. If it's a change to the constitution and it is not mentioned what kind of majority is needed, you will always assume special majority 2. However, there is a third kind where you're changing the constitution, but you're not considered serious at all. You've not been given that kind of gravitas. So for example, when you're making territorial changes, except the ones under ceding, because the Supreme Court judgment gave a clarification on that, the Berubari Union case, or when you're creating a state legislative council, these will be done through a simple majority. Will they amend the constitution? Yes. Will they be called constitutional amendments? No. For example, the Reorganization of States Act 1956, your Andhra Pradesh Reorganization Act, your JNK Reorganization Act, all of them were territorial changes. None of them were called constitutional amendments, even when they were changing Schedule 1, which had the name of the state and the area around it, because the constitution says so. It will be very clearly, explicitly mentioned in Article 4 that territorial changes will not be considered a constitutional amendment under Article 368. Very clearly written. State legislative councils, very clearly written that when the parliament creates a legislative council, it will not be considered at all under any circumstances. It will not be considered a constitutional amendment under 368. To be very clear about this, a constitutional amendment is that amendment which is changing those parts of the constitution mentioned under 368. There could be two types: seriously affecting states, not seriously affecting states. If seriously affecting states, special majority 3. If not seriously affecting states, special majority 2. Apart from that, any other law, juvenile justice, POCSO, Hindu succession, we were discussing those examples in the previous lecture, any other law, Representation of People's Act, any other law that you can think of any other nature, FCRA, FERA, FEMA, Companies Act, anything, all of these, anything which has nothing to do with 368, so everything beyond 368, any law that you make in this country beyond what is identified under 368 will always require a simple majority, right? So whether it is the triple talaq law, whether it is the child marriage law or the child labor law or the immoral trafficking law, all of them require a simple majority. There are essentially three kinds. We'll do them in detail when we do the parliament: ordinary, money and financial. An ordinary law is basically an idea. When an idea requires no money, for example, let us say you're changing marriageable age, right? That is an idea. You don't need money to change. You don't need to spend money to increase marriageable age for women. Laws which only and only require money to be spent. Let us say, for example, you need money to spend, say you're increasing the salaries for your MPs or MLAs, right? You're not increasing your MPs or MLAs, you are simply increasing the salaries of your MPs or MLAs. Just spending more money. That's called a money bill. A financial would be an idea that requires more money. Say you're increasing Supreme Court judges, so you're bringing new Supreme Court judges, and those new Supreme Court judges need to be paid the same salary, so more money needs to be paid. So it will be a financial bill. A lot of people get confused with the Supreme Court judge example because they think it will require a constitutional change. The Constitution nowhere mentions the salaries of Supreme Court judges, and in fact confers powers on the Parliament to decide the number and of course the salaries of Supreme Court judges. So this is essentially how any law on the face of this country ever gets passed. I'll give you 10 seconds. You can just quickly go through this and then I will move to the next slide. Just take 10 seconds, take a note of this, pause the video, and then we can continue with the rest. All right. Now we come to my favorite part, which is the 4 golden rules of polity. And I need you to be absolutely on point with this. If you understand these 4 golden rules, I give you my word, you don't need to memorize a single word as far as polity is concerned. There are 4 basic golden rules: democratic mandate, federal balance, separation of powers, and checks and balances. We'll study separation of powers and checks and balances together. They have 2 sub-rules each. So inter-separation of powers and intra-separation of powers, inter-checks and balances and intra-checks and balances. We'll cover each of these 4 one by one to get a sense of what we are and where we are at, right? So let's start. Rule number 1, democratic mandate. It emanates from a basic principle of life that be the change that you wish to see in the world. If you want to change the world, you want to make the world a better place, change begins from within. You've got to do things right on your own, in your own space first, and then make the world better. So an application of that principle is you require at least some form of a democratic mandate, some form of an electoral mandate, direct, indirect, explicit, implicit, some form of democratic mandate for you to perform a higher democratic function. There is a collateral relationship between democratic mandate and democratic functions. You want to perform advanced democratic functions, you've got to have the democratic mandate to begin with, to get it right in the first place. Right? Now, there are three simple examples of this. So, higher the democratic mandate, more democratic functions you can do. If you don't have a democratic mandate, you can't perform that democratic function. There are three simple examples. We'll take a basic example, a moderate or an intermediary kind of an example, and we'll take an advanced example. Let's take a basic example. Why do you think advice given by any body, whether it's a constitutional body or whether it's a statutory body, is always recommendatory in nature? Because bodies are appointed institutions. Appointed institutions can never give binding advice to an elected institution such as the government. The Finance Commission of India, even if it's a constitutional body, the recommendations are recommendatory in nature. This is why they're called recommendations. They are not binding on the government, because the Finance Commission of India is an appointed body comprised of appointed professionals, not elected. And that's the most important part. When we look at a moderate example, for example, we understand that there are elected and nominated members of parliament and legislatures. Why do you think only elected MLAs could participate in elections to the Rajya Sabha? Now, of course, with the recent constitutional amendment, we don't have nominated candidates at all in the lower houses. We've removed the Anglo-Indian category altogether. But back in the day, only elected MLAs could participate in the election to Rajya Sabha seats for that specific state. Similarly, only elected members of the Lok Sabha, elected members of the Rajya Sabha, and elected members of the state legislative assemblies participated in the election to the president. Why? Because when you're elected, you have what is called the democratic mandate. When you're elected, what you have is the propensity to perform an advanced function, a higher function, such as the election of a higher institution. Because nominated don't have that mandate. You are nominated, you haven't won an election in your life and you want to participate in the election to the president, you've got to be kidding me. An advanced example would be when the parliament is not in session. Either of the two houses of the parliament are not in session. Also applies respectively to the states as well. The Central Council of Ministers can draft an ordinance, give it to the president, who can then promulgate it, and it becomes a temporary law in the absence of the law-making institution such as the parliament. Why is that the case? Why does the Council of Ministers get the powers to draft an ordinance in the first place? Because in the case of the absence of MPs, the next best set of people who have the mandate to do so are Council of Ministers, because you've got to be an MP if you want to be a minister, if not now, at least within 6 months, so that you have the democratic mandate. It doesn't matter what kind of an MP, because even if you are a nominated MP who's become a minister, it's because the majority party has wanted you to become a minister. It doesn't matter which house you come from, because now you have collective democratic mandate. Why does the president get the powers to promulgate an ordinance? Because the president has been elected through the most exhaustive election process, and an ordinance is going to have a national impact, as it is often made on subjects in the union and the concurrent list. Why do you have to be an MP to be a minister? Democratic mandate. Why do Council of Ministers get the powers to draft an ordinance and the president the powers to promulgate an ordinance? Democratic mandate. Why do you have to be an elected official to participate in a presidential election? Democratic mandate. Why are advice given by any of the bodies recommendatory in nature? Democratic mandate. If you don't have the mandate, You can't perform that advanced function, period. It's that simple. Then you have something called federal balance. Now, federal balance is the second rule. Now, let's understand this. This rule has 3 stages. Stage 1, stage 2, stage 3. Stage 1, whenever the center is going to be stronger than the states, or it will appear that the center has more powers than the states, or is trying to sort of bully the states, then in order to soothe the ego of the states, the center will give, or there will be some appeasement given to the states. The states are going to feel very happy, loved and cared, but when they actually see the appeasement, they'll find that the appeasement is hollow, the appeasement is just a feel-good appeasement. It's very superficial in nature. So federal balance has 3 stages. First, there'll be an instance where the center is stronger than the states. 2, there will be some appeasement that will be given out. And 3, that appeasement is going to be hollow by nature. Let's look at some examples. For example, territorial changes. States have no role whatsoever in territorial changes. For example, let us say internal reorganization changes. When let's say you are chopping Uttar Pradesh into Uttar Pradesh and Uttarakhand, there's absolutely no role played by Uttar Pradesh government or legislature at that point of time. That means center is stronger than the states when it comes to territory. What is the appeasement? Before the president has to introduce a bill like this, a recommendation is required of the president, and the president is chosen by both the center and the states. And B, before the president lays the bill before the houses of the parliament, the president must refer the bill to the UP legislature for their consultation. How is it hollow? The consultation is not binding and it's just recommendatory in nature. Territory. So, simple example. Schedule 7. Concurrent list. Both the center and the states can make laws. But in case both the center and the states are making laws on the same thing in the concurrent list, the central law will always override the state law. Appeasement. If there is no central law, state law can prevail on that in the concurrent list. Hollow appeasement, the center can overrule it at any given point of time. All India services. Recruited by the center, removed by the center, but deputed to the states. Two states don't have an option to reject all India service officers, right? That's what is an all India service. Center stronger than the states. Appeasement, if you want to increase or decrease an all India service, the Rajya Sabha, which is a representation of the states, has the authority to authorize the parliament to make changes to the all India services. The conditions of service of all India services, you can't leave your state until the state government gives you permission to join central deputation. Appeasement, how is it hollow? While the Rajya Sabha can give the permission to the parliament that yes, now you can make the change to all India services. At the end of the day, the entire parliament comprising of the Lok Sabha and the Rajya Sabha is going to vote on that change. And the Lok Sabha will always have a higher number value to them. And even if the states can deny central deputation, if the center says no, we need them on an urgency basis, the states don't have an option but to comply to central requests. Hollow appeasement. Advanced example. Governor, for example, recruited by the center, works at the states, removed by the center, right? Appeasement. The governor has more discretionary powers, constitutionally guaranteed discretionary powers than the president. Appeasement. The governor will never use that discretionary power against the interest of the center because the governor is appointed and removed by the center. Emergency, for example. State emergencies can run for a longer duration without parliamentary approval. Center stronger than the states. Appeasement. Either of the houses can approve or disapprove of it. Hollow. No consultation is needed for though the governor can recommend a state emergency, but the governor is not bound by the advice of the Council of Ministers to impose a state emergency or to recommend to the president to impose a state emergency. Federal balance. Rule number 3 and rule number 4, separation of powers and checks and balances. Each of these things mean two sub-things, inter and intra, right? Let's say there are 3 branches of the state, the legislature, the executive and the judiciary. The legislature comprises of the Lok Sabha and the Rajya Sabha. The executive comprises of the elected executive and the permanent executive, which is basically ministers and bureaucrats. And the judiciary comprises of the Supreme Court and the High Court, right? Now, what are we trying to say? Inter means between L, E and J. And intra means inside L, inside E and inside J. So separation of powers is keep L, E and J as separate as possible. This is inter-separation of powers. Keep Lok Sabha and Rajya Sabha as separate as possible is intra-separation of powers. Executives separate, intra-separation of powers. Judiciary separate, intra-separation of powers. Inter-checks and balances. L, E and J keep a check on one another. Internally, they also keep a check inside on one another. So inside L, E and J is intra, between L, E and J is inter, right? Now because there is separation of powers, there will always be checks and balances, so that there is an efficient parliamentary democracy. I'll give you a simple example. The conduct of the judges, Supreme Court judges, cannot be discussed in the parliament unless you're removing the judge. Inter separation of powers. The parliament can make any law, and the judiciary, the Supreme Court, can strike that law down if it violates part 3, right? That's the sense of judicial review for that matter. This is nothing but inter checks and balances. Under very, very specific conditions, and only if the precedent orders, can there be a joint sitting in very, very rare conditions. Intra separation of powers. The Supreme Court and High Court procedures can be distinctly different. Intra separation of powers. The Supreme Court judgments are binding on all lower courts. Intra checks and balances. The legislature, especially the Lok Sabha, can pass a no confidence motion against the executive. Inter checks and balances with rule number 2, because center stronger than the states. We can't give the Rajya Sabha a say in the political stability of the center. That would mean the states have a stronger power than the center. This is also why Rajya Sabha doesn't get equal money bill powers or no confidence motion powers. Money bill, right? For example, money bill. A money bill can only and only be introduced in the Lok Sabha, right? Intra separation of powers and combination of rule number 2, federal balance. Every concept that you ever study in polity can be logically explained through 4 very, very basic, simple, clear rules. Okay? Know these rules, they'll make your life extremely easy. Which then brings me to the last part of our discussion, your reference reading list. As far as the first lecture is concerned, you can read chapter 1 and chapter 3 from pages 13 to 23 and 54 to 63 respectively of the 11th NCERT called the Indian Constitution at Work. If you are somebody who's referring to Lakshmikant, which is a good enough book, know that as far as these portions are concerned, the 6th and the 6th revised edition, which is basically the green book and the blue book, are exactly the same. There are no changes in the content. You're essentially supposed to go through 3 chapters, chapters 1, chapter 2 and chapter 3. The chapter 1 is historical background, which is also overlapping with modern history because it has your regulating acts and your charter acts. So do them together if you need to. Chapter 2, Making of the Constitution. These are the subheadings that you've got to do. Committees, enactment, enforcement, criticism, and important facts. As far as committees is concerned, you only need to know the names of the members of the drafting committee and no other committee. You don't need to know numbers in terms of enactment, the numbers of articles and all of that. As far as important facts are concerned, only do the first 4 facts which are mentioned. Then comes chapter number 3, which is salient features of the Constitution. You've got to do subheadings 2 to 7 and 12 to 16 and tables 3.3 to 3.4. 3.3 I think is sources, is the schedules to the Constitution. Just know broadly what each schedule is for: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and that's it. You don't need to do anything else. This concludes the first lecture, which was done in 2 parts of the Magna Carta. See you in the second lecture. Bye bye.